All right, let's go ahead and get started. Good afternoon, everyone, and welcome to today's briefing titled The People versus SCOTUS, Understanding the 2023 Supreme Court Term, which is presented by the Progressive Caucus Action Fund. My name is Ricardo Pacheco, and I am a Senior Legislative Affairs Associate here at PCAF, and I have the honor of moderating today's briefing. Our Executive Director, Gohar Sadeghi, was excited to join us, but unfortunately she broke her arm and is still recovering. Shout out Gohar. We hope that you get well soon. So as we get started, again, please introduce yourself in the chat. We'd love to know where you're from, your name, your pronouns, your organization, and yes, the temperature where you're at, because a lot of us are sweating out there. So as many of you are probably seeing a poll popped up on your screen, please be sure to answer as it kind of helps us understand what you want to learn and how you want to be engaged during today's briefing. So before we actually commence the briefing, I do have 3 brief housekeeping notes. First, we are going to dig deep into policy discussions today, but we will not engage in any electoral or partisan conversations during the session. Second, we have enabled automatic closed captioning. So if you go to the bottom of the screen and click on live transcript, you can enable the closed captioning. It is an AI, so it is often imperfect. So we'll also be adding improved captions before we send the video of this event to you later this week. Lastly, we encourage you to ask questions of our incredible panel. These briefings are only as good as the audience engagement, so we appreciate you asking any questions and just engaging with us and our lovely panel. You can drop your questions in the chat or in the Q&A box at the bottom of your screen, and we'll get to as many of those questions as we can. So with that, today's briefing comes at the end of yet another devastating set of decisions from the Supreme Court, captured by an extremist supermajority. Many of us are still grappling with the life-threatening consequences of last year's term when the Supreme Court decided to overturn Roe v. Wade and Dobbs curtailed our ability to regulate gun violence and take action to protect the climate and so much more. This term, we faced another set of hugely consequential cases that hit at the heart of voting rights, civil rights, the right to organize, our right to drink clean water, and so much more. We can't possibly go into detail on each of these cases that will inevitably shape our communities this term, but we're going to do our best to understand what's changed and how the Supreme Court's decision will impact our rights and what we as a movement can do next. And so I'm so very grateful for our incredible panel who are here today to make sense of this term. So without further ado, I'm going to introduce them each briefly, and then we'll dive into our conversation because I want to make sure that we leave plenty of time for your questions so that this truly is a conversation and a learning environment. Again, remember, you can drop your questions into the Q&A box below, and we'll get to them as soon as we can. So first, I am honored to introduce Rakim Brooks, who is a president of the Alliance for Justice. Rakim graduated from Yale Law School and Oxford University, where he was a Rhodes Scholar. He is committed to a judiciary that reflects America's diversity and the Constitution's promise of a more perfect union. He previously served as a campaign manager for the ACLU Systemic Equality Campaign, an attorney at Sussman Godfrey, where he sued opioid manufacturers and worked with free incarcerated people during COVID-19, among many other critical issues, of course. He also served as a member of the Biden-Harris transition team after previously serving as a policy advisor for the Treasury Department during the Obama administration. So thank you for being here, Rakim.
Thank you.
And next, I am so delighted to welcome Chelsey Davidson. Chelsey is the policy counsel at Take Back the Court Action Fund, which works to inform the public about the danger that the Supreme Court poses to democracy and about the viability of court expansion, which is adding 4 seats to the court as the only strategy that rebalances the court after its 2016 theft. Chelsey is a progressive advocate with experience in election protection and environmental advocacy. She received her JD from Stanford Law School in June 2022. Chelsey, thank you for being with us.
Thanks so much.
Awesome. All right, so let's get started into the discussion. So Rakim, again, there are so many important cases to talk about this year that I honestly don't even know where to begin. So let's just start with the last few days of the term, where the court issued some devastating rulings on affirmative action, on LGBTQ plus rights, and of course, student debt. How do we understand these cases, and what ripple effects do you expect?
Sure. Well, thank you again for having me. This is a really important conversation at quite a depressing time. I've told my fellow panelists that, like the justices, I left the country right after the end of term, knowing how much damage they had done, and now I'm back in the saddle trying to do the work. So you're exactly right. And the way I might categorize this term is that on the democracy issues, we did okay. And then on the cultural issues of our time, from the rights perspective, the empire sort of struck back. So as you started with affirmative action, that has been a decades-long campaign. If what abortion is to Samuel Alito is what affirmative action was to John Roberts, it has been one of his core animating issues of concerns about how race and, as he puts it, racial preferences show up in our society. Going back to his time in the Solicitor General's office in the Bush administration, and one thing that the first Bush, and one of the things that I often remind people of is that John Roberts actually clerked for William Rehnquist, who advised his boss, Robert Jackson, not to overturn Plessy v. Ferguson. So it actually goes back that far. And that's one of the things that we at the Alliance for Justice try to keep focus on, which is this is a decades-long campaign to change our law, to reverse the progress that was made in the second half of the 20th century, and really, as they say, make America great again, which is to take us back to a place that most people of color and women, and in fact, most working class white people would never want to go back to. So that's where we've ended up. So the affirmative action case is huge blow, predictable, unfortunately, based on Justice Roberts' prior statements. And now he has, as you stated, the supermajority he needs in order to advance that crusade. That's not the end of it, I should say. Affirmative action only touched racial preferences in higher education, but you can expect that there will be additional attacks on on diversity initiatives writ large, whether they be on corporate boards or in hiring in other places in our society going forward. I'll touch quickly on the student debt case. That one is wild if anyone reads it. So here's what John Roberts said to us. He essentially said that a loan modification could not include cancellation. Now, for any of you who have a mortgage or any other loan, you pray for the day, in fact, that your creditor says to you, I'm modifying your loan. And oftentimes that can include extending the term of the loan, or reducing the principal of the loan, or the interest. It can include any number of things, as we all know. And yet the Chief Justice, as Elena Kagan pointed out so poignantly, has decided that the Supreme Court knows better than the federal government how, in fact, it should manage its loan portfolio. It's truly an outrageous decision that reaches far beyond anything that we've ever expected courts to do. And so again, I recommend to you Justice Kagan's dissent in that case. And finally, we should focus on 303 creative, which is another culture issue, so to speak. All these are democracy issues at base, but I'm just sort of using that as a cheap way of defining them. So 303 creative was, of course, about the right for LGBTQ people in particular, but really anyone to have services rendered to them on a non-discriminatory basis. The court ruled that it would violate the First Amendment rights, and this was of the website designer, to force them to make a website for a gay couple. Now, here's the thing that also reveals the absurdity of this present court. If you read Neil Gorsuch's decision, he compares it to having a Jewish person make a cake or provide some product to a Nazi. I did not know that LGBTQ people were functionally equivalent to Nazis or any other group. I mean, this is sort of the route that the conservative right would take us on, which is a series of absurdities that ultimately lead us nowhere that anyone wants to go other than them. And so it was a depressing end to the term, and unfortunately, we can expect more of the same in the future.
I think it's also really important to highlight just how bizarre these cases are in the standing context as well, because the right-wing justices have historically been very, very exclusionary about who can actually bring a case before the federal judiciary. And in all of these cases, but especially in 303 and the student debt case, we saw them completely twist their own doctrine to allow these cases even in the door. In the student debt case, they're essentially saying that companies within state borders that are functionally independent from the states themselves, the state can sue on their behalf, even though the agency or the entity at issue in this case, MOHELA, did not intervene in the case. They did not say they wanted to be anywhere near it. And in the 303 case, you have a person who does not run a website design business or a wedding website design business. She was not approached by any specific gay couple saying, hey, we want your services, and fabricated a lot of the documentation that she needed to get into the door in the first place. So not only are these functionally bizarre on the merits, but also when you look at the procedure behind them, the court is abandoning all of its own rules in order to enact a right-wing agenda.
Yes, thank you for those thoughtful answers. Chelsey, this next case that I want to talk about, it hasn't gotten as much attention as the ones we've just been discussing, but it will have serious long-term implications. And that case, of course, is Sackett versus EPA, a case that focused on the Clean Water Act. Can you tell us a bit more about this case?
Sure. To start, I would like to go way, way back to 2022 when the Supreme Court took up a similar case attacking the Clean Air Act. So the Clean Water Act and the Clean Air Act were the twin pillars, if you will, of the environmental movement in the 70s. They both passed with bipartisan support, and they have been, modified and amended and revitalized across the years with bipartisan support as well. So the fact that we are now at a time when these two very important acts are being eviscerated by the Supreme Court is extremely scary and frightening. So last year in the Clean Air Act case, the Supreme Court essentially ruled that the EPA does not have the authority to regulate power plant emissions, which is huge for us in regulating climate change, which, as I'm seeing from the chat, all of us are experiencing right now in some way, shape, or form, or most of us are. And they did not let that sit for very long. They did not let us even have time to sit with the fact that our environmental protections were being stripped away from us before they came at it again with the Clean Water Act case. So Sackett versus EPA directly impacts wetland protections. Now, before we had wetland protections in the US, we were losing something like 400,000 acres of wetlands per year. And wetlands are hugely important for a number of things. We don't really think about them as much as we should, but wetlands are incredible ecosystems that do a lot of services for us humans. One major thing that they do is they sort of soak up water, think of like a sponge, and they actually release it during times of drought. So it can make droughts less severe, and it can actually soak up some of that flooding that we see happening throughout the United States. So they're very, very important for protection of property and for also making sure that, that we are a little bit more drought resistant. But the most important thing that they do is they filter water. And without these wetland protections, 117 million Americans drinking water is now at risk, or up to that many. States can enact their own protections, but the federal protections of 50% of the nation's wetlands were just stripped away from us a month ago by the Supreme Court. The industry backers of this case are monumental and wide sweeping. You have the cattle industry, home building industry, you have the mining industry, all filing amicus briefs in this case. It's framed as, oh, this couple just really wants to build a home on this lot that they've had for 10 years. But that couple actually owns and operates a commercial excavation company that wants to dump fill into wetlands. So when you dump fill into wetlands, it comes downstream, it affects water quality, and it will affect the drinking water, the recreation water, and all of us across the United States for 50% of these wetlands. So it's an absolutely devastating, tragic case. It was truly the worst possible outcome in this case. And that's what they decided to do to the Clean Water Act this term. So as we're facing these increasing environmental crises, not only are we not able to go farther from what we have done historically, but we're not even able to maintain the historical status quo of environmental protections.
Could I add one thing to that?
Please.
Yeah, so Chelsey has so excellently laid out exactly what happened in that case. We at AFJ started to joke around that the moniker for the case was, "Are wetlands wet enough to be water?" That was, and the reason that was important for us to capture is because, as the dissents point out, the conservative justices were taking or embodying the role of scientists, which we all know none of them are. They're barely judges at this point, but they certainly are not scientists. And so the whole case revolved around this idea of whether or not wetlands were in fact wet. That was the whole thing. And I don't know, I certainly don't feel qualified to make that decision. I went to law school, so I'm not sure where they went to law school such that they felt qualified to make the decision. But that's what we're confronting, not just in the context of the environment, though, as Chelsey points out, it's become most pronounced there, but across numerous federal agencies where the justices are beginning to insert themselves increasingly in saying that Congress has not appropriately delegated its authority to the federal agencies such that the federal agencies are empowered to make these decisions. Now, that was a whole lot of blah, blah, blah. So let me explain quickly what I mean. What Congress has rightly done, which is what we should all be doing, is trust the scientists. They have said, we lack the expertise to make the decision about whether or not this plot of land is wet enough to be a waterway of the United States. So we're going to ask the EPA to do so. And the court is coming in and saying that does not seem to be a reasonable decision. So I would ask all of you, does that seem to be a reasonable decision? Should it be the case that we as a democracy say we're going to leave to the experts the areas that they have trained for in order to be experts, and allow them to make the best decisions on behalf of all of us? Or do we say we're going to punt that to this court, which is composed of, as Chelsey said, several ideologues who are being pushed and persuaded by industry interests to do something opposite what would be in the best interests of the American people?
Thank you, Rakim and Chelsey. And we're definitely going to talk about Supreme Court, ethics and recusals and reforms later on. Right now, I think the next topic I want to talk about, and there's a lot of interest, of course, is about voting rights and the future of democracy. There were several cases this term about voting rights, including Merrill v. Milligan and Moore v. Harper. Starting with you, Rakim, and then of course, Chelsey, please feel free to jump in as well. Can you talk a bit about these cases? It does seem like we avoided the worst outcomes in Merrill v. Milligan and Moore v. Harper. But does that mean that our democracy is safe? And what's next for the fight to restore voting rights and protect elections?
Sure. Chelsey, which one do you want? And then I'll talk about the other one.
I'll take Merrill.
Okay, cool. All right, so I've got Moore v. Harper. This is perfect because remember that little guy I mentioned a little while, William Rehnquist? Well, this is like the ghost of William Rehnquist comes back again. So how did we even get here? Unfortunately, I got to take you back 2 decades. Just bear with me. It won't take that long. We go back to Bush v. Gore. Everybody remember that, right? We're in Florida, we're counting hanging chads, and the Supreme Court comes in and says, you have to stop. You have to stop doing this. And William Rehnquist, at that point, Chief Justice of the Supreme Court, says, I read the elections clause, and I'm kind of convinced that the Florida state legislature has more authority on this than the Florida state Supreme Court. Now, if you recall, the Florida state Supreme Court had ruled in favor of Al Gore and basically said that the count should continue. So conservatives didn't need that decision at that point. It was just a concurrence. Flash forward to 2020, and we have all of these battleground states where Donald Trump is alleging that there were election irregularities, and lo and behold, who's it coming to? The state Supreme Courts to be the final arbiters of those decisions. This is not partisan, I should say. This is just factual. This is what happened. So he went to all of these various courts and was rebuffed. Now, had those courts been differently constituted or had the power to decide those elections and things like whether or not ballots that were mailed on election day and received after election day, whether or not those should count, been left to other bodies, perhaps state legislatures that were more favorable to the former president, he might have received a different outcome. Hence, Moore v. Harper. We now have a case that comes along that essentially argues that the founders of our republic had no interest in state courts participating in the administration of federal elections. And as a consequence, and that they believed, that all of that should be left to state legislatures. Now, this is absurd. This is an argument that has never been made other than that one time that I told you about in 2000 in the history of our republic. At no point did any state legislature ever say when a state Supreme Court was ruling on a matter, on an election matter related to a federal election, you know what, you really don't have the authority to do this. They've never tried to strip their state courts of the authority for doing this. We'll talk about jurisdiction stripping later, I assume, with regard to our present court, but that had never happened. And so it was a totally absurd argument, and luckily it did not win the day, except Justice Kavanaugh left in his concurrence the idea that perhaps, so long as these are federal elections, they should always be within the reach of the Supreme Court. Now, that naturally follows because they are federal elections and the Supreme Court oversees federal law. But you wonder why he needed to say that. And this goes back to a theme that we will return to over and over again, which is there is a deep and abiding collusion going on between our current court and advocates around the country, conservative right-wing advocates, where the justices signal through dissent or concurrence lines that are entirely unnecessary to decide the issue at hand, so that the advocates know which cases to bring next through your favorite Matthew Kacsmaryk or Fifth Circuit judge, so that they arrive back at the court, now formed potentially in a way that allows the court to decide differently. So as Ricardo said, we avoided the worst, it seems, in that there were a majority of the justices who looked at this case and said, this seems like a bridge too far. And yet I would say that they were handed a lifeline, that being the advocates who would pursue these sets of arguments for future litigation.
And I will take Merrill versus Milligan and talk about the 10-year assault on the Voting Rights Act and gerrymandering. Thank you so much, Rakim, for that incredible explanation of Moore versus Harper. I'm angry anew. So in Merrill versus Milligan, we have a gerrymandering claim, but I think it's worth also going back a full decade to talk about John Roberts and his other pet project, which is taking apart the Voting Rights Act piece by piece until it is functionally toothless. So the Voting Rights Act was a monumental piece of civil rights legislation that ensured that racist voting practices had to go through federal review. Like states with a history of racist voting practices could not change their state laws for federal elections without going through a federal review process. And it put in place a nationwide ban on racial discrimination in voting found in Section 2. So in Shelby County versus Holder, which was a 2013 case, the justices ruled that the formula for deciding which jurisdictions needed to go through that federal pre-clearance process was null and void, which effectively dismantled both Section 4B and Section 5 of the Voting Rights Act. This was perhaps one of the worst voting rights cases we have ever seen. Within hours, states started implementing racist voting practices and laws within hours. And I believe within 5 years, 23 states after Shelby County versus Holder had implemented wholly new racist and regressive voting practices in their states. But the justices weren't done there. They had multiple Section 2 cases in which they stripped away Section 2 rights. 19 states after those decisions also enacted racist voting practices. And then here we have Merrill versus Milligan come up in 2023. So a full decade after this piecemeal assault happens, right? In 2022, the justices ruled that it was too close to the election in February of 2022 to get rid of what the state courts had already determined was a racist map in Alabama that had basically said, even though Black voters make up 2 out of every 7 voters in Alabama, we're only going to make 1 majority Black congressional district. Now, even though it was already shown that this was a racist map, the justices were like, oh, it's way too close to the election to be able to change it. So we're just going to leave that map in place, that horribly racist map for the 2022 midterms. They did the same thing with a Louisiana case, and members of the judiciary in other states also just left similarly racist maps in place. Now, the total impact of those decisions was that 7 to 10 House seats that probably would have gone to one party went to the other party. And right now, there is only a 5-seat majority in the House of Representatives. So the Supreme Court effectively, by issuing a decision that it was too close to the election, left in place these racist maps and stole the House of Representatives, just point blank. Now that the election is over, they're like, yep, these maps are racist. They have to be thrown out. Sorry about that, oopsie. But the impact is that Black voters in several states were denied their opportunity to have equal voting rights in the House of Representatives. And the impact on the House of Representatives is that an entirely different party controls it than might have otherwise had we had a true and functioning democracy. So it's an extremely bad decision. It's a good decision on paper for this particular year, but the history shows us that there is an unbridled assault on voting rights. And this decision comes a year too late, frankly, to have any meaningful impact on the midterm elections. Justice Roberts also signaled bring me another case in this decision by saying, you know, even though this map is really, really racist, it might be possible that race is too important in allocating political power. So bring me a slightly less bad map, and I will continue my assault on Section 2 at that time.
Mm-hmm. Chelsey, tell them about what Alabama did after the decision.
Why don't you tell them, Rakim? I need a sip of water.
Okay, cool. Go ahead, Ricardo. I'm sorry. I didn't mean to.
No, that's actually perfect.
Oh, you're fine.
No, that was going to be my follow-up question. You know, is we want to wait a little bit for audience Q&As.
But they're refusing to enact
Yeah, Chelsey, please go ahead if you want to, talk about what Alabama did following the Supreme Court ruling. And I think a general question also is, what power does the Supreme Court have to enforce their rulings? I think is an audience question that was also submitted.
Well, that's always an interesting question. The Supreme Court is a co-equal branch of government, but at the same time, a lot of enforcement mechanisms are lacking in the Supreme Court, and Alabama is showing that they don't have an intention of following this ruling right now. So I think it's going to be very interesting to see how things play out. It's very disturbing to watch a quote unquote good case not be implemented. And I mean, please, Rakim, if you have more that you would like to say, please jump in. But it is extremely scary to see this selective adherence to the Supreme Court.
Yeah, just to make sure folks are clear on what's happened. So since the Supreme Court has ruled, Alabama has drawn new maps. Now, what the court asked Alabama to do, ordered them to do, in fact, was to redraw the maps so that the Black citizens of Alabama had a reasonable likelihood of being able to elect the representative of their choice. That would have meant drawing essentially 2 Black congressional districts, majority Black congressional districts. Instead, what the state of Alabama has done is still drawn 1 majority Black district, then drawn a 40%, I believe, Black district, and said that satisfies the court's requirement. This gets back, though, to the point that Chelsey's making, and we're going to make over and over and over again, which is there is the most disgusting is the only word I can think of, because we're really talking about people's rights to equal citizenship in the country, but a kind of ongoing conversation between the court and the most radical elements of our society regarding how we should be structured politically. So Alabama, some people think Alabama is doing this outright to resist the court's order. I perhaps am a little more Machiavellian and think that's not what's happening. What they're doing is, to Chelsey's point, reading exactly what the court wrote and saying, can we draw a map? If they've said this one is too racist, can we draw one that's slightly less racist that will ultimately survive the court's scrutiny? And the only reason they're doing that is because the court has said, almost like the Grutter case where Sandra Day O'Connor said we should only be using race for 25 more years in admissions. If you read the Milligan case, you'll see that they make allusions to something similar, which is, isn't the time for considerations of race in the drawing of our districts at an end or near its end? And so Alabama is just tempting fate in some ways. They believe that things are headed in their direction where they'll be able to maintain total control of the state politically by disenfranchising their Black voters again. Remember, Alabama has a long history of doing this, which I know personally because that's where my family is from. But all of this, it all really stinks and it reeks because, as Justice Kagan said, both in oral argument and at other points with regard to the Voting Rights Act, this was the crowning achievement of the Civil Rights Act. Again, going back to the beginning of my remarks, this was one of those things that happened in the second half of the 20th century that was really special for our democracy. It was an attempt to fully realize the idea of equal citizenship, and this court seems hell-bent on tearing that apart.
Thank you. All right, I want to pivot a little to another case. There were several other cases where the court stopped short, of the worst outcome. Including in the case attacking the Indian Child Welfare Act and tribal sovereignty, which was Bracken v. Holland, and a case that had the potential to undermine the right to strike for working people, which is Glacier v. Teamsters. Can you both talk about these cases a little bit?
Sure, Chelsey, I was just talking. You want to jump in?
Oh, sure. I'll start with Glacier and then you can jump in with Rakim. So Glacier Northwest versus Teamsters was a right to strike case in which the Supreme Court essentially ruled that when it comes to perishable products, at the very least, simply abandoning the perishable products is enough to get you a sort of vandalism type position for the striking workers that allows state courts to take up the case. So just to give a little bit of New Deal history, essentially back in FDR's day, they set up a particular body to hear right to strike cases and anything related to labor relations. And the goal of that body was to regularize labor law and strike law across the country so that whether or not you were found to have a right to strike didn't depend on sort of which jurisdiction you were being sued in, right? So it was very, very important. And what the Supreme Court has just said is that business owners can sort of evade that body and take these cases to state Supreme Courts by framing strike-related activity as being illegal or illicit, right? So it's not protected under your right to strike to do something violent or to intentionally destroy property, right? That would go into the state court realm. So what they have essentially done here is in a case regarding wet cement, they have ruled that anytime there is a perishable product at issue in a strike, that case can be taken by the state courts and rather than going through the centralized federal body, right? And so that's very, very damaging to the right to strike because it means that when you are an employee and you are going on strike, you have to factor in these sorts of considerations of, am I going to be sued for tens of thousands of dollars? Is my union going to potentially go bankrupt because we're subjected to these huge state court tort rulings over something that should be protected striking activity? What's disturbing to me is that some of our most vulnerable workers are workers that handle perishable products, especially produce, agriculture, groceries, you name it. These are some of the workers with the fewest protections. And now these unions might have to calculate whether or not to strike in the first place because they have to now potentially face a state court tort claim rather than having this case heard by a federal body to determine whether illegal activity occurred or how the dispute should actually be resolved. It's very, very disturbing for the right to strike. And I'm sure it goes along with another 10-year pattern of unbridled restrictions on labor, pro-business decisions, et cetera. And it just shows us that this is not going to be the last step. Today it's perishable products, but as more and more workers strike, as we're seeing these big profile Hollywood strikes and we're seeing potential UPS strikes, it's going to pervade more and more areas of commerce. It's going to affect more and more workers. And it is going to, once again, just make those scales, which are already tipped so much in favor of corporations, tip even further.
Really well said, Chelsey. And I would only add to that, again, a piece of history which many people on this call will likely be familiar with, which is prior to the National Labor Relations Act, business owners frequently used state and local courts and tort claims in particular as a way of killing labor activity. And so this is sort of a flash to the past yet again, where the court is effectively colluding with business interests to reimagine society in a pre-1965 lens. And we just always have to keep that in mind. What is the world that these court decisions result in. And it is actually a world that we've lived through, that we're familiar with, and with the benefit of hindsight, know was ultimately a world that was quite repressive of any number of groups, and fundamentally did not honor the equality that's supposed to be enshrined in our Constitution. And so anyway, I just wanted to add that piece to what Chelsey said so eloquently. On the Indian child welfare case, which is the Rakim case, it was another one where we were surprised by the victory. It was a place where they seemed to stick to some of their standing rules and trying to understand whether or not a challenger could bring it. For a quick summary of the case, I'll just say the thrust of the case rather than all of the legalities. Like, why is this coming? Why are they motivating these cases? It's again actually a race case, right? It's deciding whether or not a family. The Indian Child Welfare Act ultimately says you should try to place a child within a tribal family rather than someone else. The court is dubious of that claim and claims like it because, again, it relies on racial distinctions that they think are pernicious in our society. And so ultimately the case is rebuffed, I think, on rather technical reasons. But we need to understand it as part of a broader process of creating a kind of colorblind society, which eliminates all the racial categories that, of course, no person of color chose to label themselves with, and certainly the tribal, that Native Americans did not choose to label themselves with, and strips them of the ability to manage their personal relations. That's sort of a quick and dirty on it, but I don't want to linger there too long, because actually it's a very complicated case that moves around in a bunch of different places. And not to say that our august audience couldn't understand those things, but really, if we're keeping with the theme of what the court is doing, it's another race-based case that turns out the right way, but only quite narrowly.
Yeah, and I think on the Indigenous cases as a whole this term, it was split, right? So they did recognize the classification of American Indian as a citizenship classification, which was great. But they also were like, the United States does not have to abide by its treaties with the Navajo Nation. It does not have to respect Indigenous water rights in a different case. So we're definitely seeing sort of a mixed bag in the Indigenous space, but it is certainly not a good term for Indigenous rights as a whole. And I think it's really, really important to also show how bad it was from a water rights perspective, not only for the EPA, but also for Indigenous sovereignty in the Arizona v. Navajo Nation case.
Thank you both for that. I think right now we can go ahead and start turning to audience Q&A. We've had a lot of interest. Thank you to the audience for your questions, for participating. So I want to talk about the politicization of the court. So again, this next question is in response to a lot of comments in the chat. Many of the audience have mentioned things like, what's happening with the Supreme Court is shameful, that the Supreme Court cannot be questioned, and really there are bigger issues here at play. So a question, for both you, Chelsey, and Rakim, what can we do as advocates, or rather, what do we do as advocates and as concerned citizens? What is your opinion on what needs to happen next? Is that Supreme Court expansion? Is that court reform through, the Supreme Court Ethics, Recusal, and Transparency Act, which is, making its way through the Senate? What else? What do we do, and what needs to happen next?
Well, Chelsey has a very strong opinion about this, so I'll leave that piece to her. One of the pieces that I think, so overall, opportunities like this are great, right? We should be coming together as a society and talking about the role that the court plays in a democracy. And so when the court is frequently striking down major acts of Congress or reinterpreting them in ways that seem inconsistent with congressional intent, we should be asking ourselves whether or not the court has the ability to do that. Now, of course, judicial review is a longstanding practice in our society, but you usually have at least 3 and previously 4 justices on the other side saying, you shouldn't be doing this. We shouldn't be doing this. And so I always try to remind people, you shouldn't be afraid of the legalese, because you've got quite prominent lawyers saying that the court is doing the wrong thing at the time that it's doing something you disagree with. But in terms of then thinking about what solutions might be, someone in the chat has talked about term limits. That's, of course, a good idea. Other folks have talked about jurisdiction stripping, which I mentioned earlier. The idea there is that you limit the ability of the court to hear certain cases. The court's original jurisdiction, which is the jurisdiction granted to it by the Constitution is actually quite limited, and it's through federal statute that we've allowed the court to hear all sorts of cases about the Clean Water Act and the Clean Air Act. Congress could revise those statutes. And something that's a little talked about, and I've pushed here and there, but not really pushed too hard, so you all should be the judge of whether or not this is a good idea, is I think there should just have to be unanimity. Don't allow for 5-4 decisions, 6-3 decisions, anything that ultimately calls into question the legitimacy of the court. They have to be 9-0 or 7-2 or something like that. The reason I think that that is, in fact, one of the strongest remedies to what ails us is because so many folks lose faith in the rule of law because it seems now and is, in fact, partisan. Whoever the president is who appointed the justice can usually be assured that that justice will reliably implement the political agenda of their respective political party. And that's not what the rule of law requires. And so we always feel more confident, we as the public, I believe, feel more confident when we see a 6-3 decision, not now because they have 6, but prior to that, 7-2 decisions, 8-1 decisions, 9-0 decisions. You might disagree with the decision, but you certainly don't think that the decision is necessarily covered over with partisanship. As much as I disagree with the Glacier case, which was an 8-1 decision, I at least see that Justice Kagan and Justice Sotomayor were in the majority, even if I ultimately agree with Justice Jackson's legal reasoning, right? It no longer becomes about the partisanship of the court. And so whether or not this is constitutional is sort of arguable. There's, you ever take the federal courts class at your respective law school, or you nerds out there somehow find a course online, you'll learn about rules of decision. And so there's a separation of powers argument that Congress can't necessarily regulate rules of decision that the court uses. I'm not sure that that's right, but if there were a solution that was going to bring us back from the brink of things where we could have a court that folks could trust again, that they felt were ruling as the law required and not as their political party required, I think it would be a rule of unanimity.
Thanks so much for that, Rakim. It's a very, very interesting idea. I have questions as to how it would apply to the lower court, since I know that we also have a very stacked lower court system. So leaving in place lower court decisions might have similar problems, but I think it's wonderful to bring that idea to the discussion, and I'm really happy that I got to hear it. Our approach at Take Back the Court is a little bit different. So we do endorse a variety of reforms. We believe that there needs to be a code of ethics for the Supreme Court. It's absolutely wild that there isn't one. We believe in the term limits ideas that we have seen many good ones in terms of making sure that the composition of the Supreme Court doesn't just depend on who dies or retires when. Like, that's a very bizarre way to allocate power on the nation's highest court, and regularizing appointments would certainly be something that we support. I hope that the beginning of this discussion really showed you that whatever issue area you care about Supreme Court expansion. And I think that, or at least Supreme Court reform. And I think that what I want to sort of delve into is that specifically you care about Supreme Court expansion if you care about any of these issue areas and you care about Supreme Court reform more broadly, right? So Supreme Court expansion is this simple idea. The Judiciary Act of 2023 would just add 4 seats to the Supreme Court to immediately and effectively rebalance it. Why 4? Well, again, just to give a little bit of a history, this isn't partisan, this is just what happened. We had a right-wing theft of the Supreme Court starting in 2016 when the Senate refused to even hear the nomination of Merrick Garland. They shrunk the size of the Supreme Court for more than a year without going through the regular legislative process. Mm-hmm. And then they threw out their own rules decrying, oh, well, whoever, the next election should determine who gets the seat. They threw out those rules in 2020 when they rushed through the nomination and confirmation of Justice Barrett after 63 million people had already voted in that election. So without those 2 decisions, we would currently have a 5-4 liberal Supreme Court. And the whole point of adding 4 seats is to get us back to a narrow liberal decision or liberal court that more closely matches the composition of the country. So it would be 7-6. There are a number of reasons why Supreme Court expansion, we believe, is the best and most tried and true way of reforming the Supreme Court. The first is that it has been done 7 times before. There is no constitutional question whatsoever that this is legitimate, that this is how the framers wanted to do this. You have half of Mount Rushmore changing the size of the Supreme Court. So it is a tried and true way. It also has a really important history in the Reconstruction era. The Supreme Court was expanded, or the sizes of the Supreme Court changed, I believe, 5 days Congress passed it after the 14th Amendment. So it has a huge history in the Reconstruction movement. And it also has a really important history in the New Deal, right? So the switch in time saved 9 is something that we all learn about in history. And basically what happened was that the Supreme Court was sufficiently threatened by the possibility of reform that it allowed the Minimum Wage Act to stay in place. It did not encroach on FDR's New Deal. And so when it comes to Social Security and so many of the things that we still care about that happened in the New Deal, we have expansion to thank for it. I think it's really, really important to remember those things. So what do we do here, right? So we have a bill on the table, the Judiciary Act. We already have 65 co-sponsors in Congress, and we need to get that number up. When I first started working for Take Back the Court as a research assistant back in 2020, this seemed like a pipe dream, but we already have legislation now. We have more than 130 organizations supporting Supreme Court expansion in the Judiciary Act. And I think it's really, really important that we remember that even though we don't have a governing window to get this passed right now, that building momentum is extremely important to do now so that when we have a governing window, it's ready to go. I think it's also important to remember that there has been one party control of the Supreme Court for more than 50 years. And political scientists have looked into this, and it looks like that without Supreme Court reform like expansion, there is likely to be one party control of the Supreme Court until 2065, which is 43 more terms like this one that you've just heard about, before that there is any sort of meaningful check and balance on the Supreme Court, right? It's not supposed to be one party rule for 95 consecutive years. That is not how democracy works, especially when a majority of current sitting Supreme Court justices were nominated by a president that lost the popular vote, at least initially. That is a bizarre setup for a democracy to have. And it is way too much power to concentrate in a body that is wholly unaccountable to the voters right now. So they know that they cannot get a right-wing agenda through the electoral process. They're imposing it unilaterally from the bench, and we have to stop them. Unfortunately, like, as much as I love ethics proposals and I love term limits proposals, I'm very, very scared, and I think rightfully so, that this Supreme Court has shown us time and time again that it is not going to willingly accept checks on its own power that it does not have to accept. We're already seeing the seeds of this in letters written by Harlan Crow and Leonard Leo's lawyers, saying that that Congress has no constitutional authority to place any ethics checks on the Supreme Court, and therefore investigations into their illicit contributions are illegal and illicit. That's terrifying, and I think it's also very likely that we could see that walk its way into an opinion in the future. So as far as other reforms, we back them wholly, but expansion must come first. And I hope that, any questions that you have on expansion, I'm able to answer for you today.
Thank you, Chelsey. I do have a couple follow-ups, from the audience on court reform, court ethics, and court expansion, right? First, I know you mentioned, the Judiciary Act. Is there something that President Biden can do unilaterally to expand the court, or is that the responsibility of Congress? And in addition to that, we've talked about, term limits for justices, Supreme Court expansion, ethics reforms. Is one better than the other, or do we need all three? I'd like to hear from both, Chelsey, both of you.
Sure, I'll take the first one. Yes, it's Congress's responsibility to alter the size of the Supreme Court, if that's the scope of the question. President Biden would need to sign the legislation, the Judiciary Act, when it passed through both chambers of Congress, but President Biden cannot unilaterally change the size of the Supreme Court. Now, when it comes to term limits and ethics proposals, I do think that there is a real risk that the Supreme Court would rule that one or both of those are unconstitutional. And I'm not saying that they are unconstitutional. I'm a big fan of both proposals, but I think that we've seen a lot of judicial activism by the Supreme Court, and I think that we could expect that in any attempts to constrain their power. So while we support those ideas, we really think that it's a matter of order, right? So we have to prioritize these based on the order in which they need to be implemented. You first need to establish a Supreme Court that believes that the Supreme Court needs to be reined in. And that requires adding 4 justices who would ultimately uphold term limits and ethics proposals before we can actually get to those term limits and ethics proposals.
Great. So there's so much that's been said and I have so many reactions. Hold on, let me just zen myself for a moment. I missed all this. Well, one thing I wanted to say, Chelsey's offered a really compelling case for court expansion. I know many of you may not be there. I was not there for quite some time. And I just want to offer, as a sort of fair weather expansionist, some thoughts about it that would also encourage and I think lead to the same conclusion. If you're concerned about manipulating the size of the court, I think Chelsey's argument is really compelling that the size of the court has already been manipulated. It was forcibly kept at 8 for months going into years, over a year, I guess, for the purposes of securing a Republican majority. And so as a consequence, you shouldn't, I mean, if you think that meddling with the size of it is a problem, one side has already done it and therefore delegitimize the institution. What we're trying to do is re-legitimize it. If you're concerned that adding 4 doesn't really re-legitimize the institution, but rather make it more partisan than it was before, I think it's worth remembering that the current composition of the court is the result of a long-standing partisan effort to only put certain types of people on the court. So it was the Federalist Society that launched essentially the No More Suitors campaign. Remember David Souter, Republican appointee, or John Paul Stevens, Republican appointee? There will never be another Republican appointee like the two of them because there's been a long-standing conservative effort to make sure that there's never another person like them. And that would include justices like Justice Kennedy, who on everything but gay rights was extraordinarily conservative, but on that one issue didn't give them exactly what it is that they wanted. If we're wondering about how we get to number 4, I saw someone also point out that, well, it used to be the case that the number of justices roughly map the number of circuits. We have 13 circuits. We only have 9 justices. Simple enough way of thinking about expansion. I think another way of thinking about it is the way that Chelsey did at the outset, which is that, you know, the seat that Justice Gorsuch sits in was stolen from the proper political process. The seat that Justice Barrett sits in was stolen from the proper political process, at least announced in the Merrick Garland travesty. And then you say, well, where did the other 2 come from? And that's where Alliance for Justice has really been pushing that Justice Thomas and Justice Alito need to resign. They have violated every single basic norm with regard to judicial ethics, which they know because they previously served on courts of appeals that were bound by codes of ethics. And so we've really been pushing for their resignation. Of course, they won't resign because if they're not willing to do what's right on the court, why would they be willing to do right by the court by resigning? So there needs to be a widespread push, not just for expansion, but for their impeachment. And if the impeachment is unlikely, as we all know it is politically at this moment, then expansion becomes the next reasonable thing to do in order to account for those 4 seats that have effectively been stolen from the American people based on malfeasance and then based on political malfeasance of a variety of kinds. So at least that's how we at AFJ think about it. The term limits point, I think Chelsey's right, for potentially suffers from some constitutional infirmities that we can't be sure about. Someone asked, how is it that you would create the rule of decision that would require unanimity? It's actually quite the same as it'd be an act of Congress. And all you would need to do, in fact, is say that for any cases being heard by the court, not in its original jurisdiction, for instance, that the case has to be unanimously decided by the court. Now, folks have worried about that. Let me just say one thing. For all, I would have preferred that Merrick Garland was sitting on the court. But, and this will be my last point, those few months when it was a 4-4 court were glorious as far as I'm concerned. They were. Look back at those years and see, did you sweat at all when June came around? it was the most satisfying period where you realized that they had to come to decisions that both sides could agree on, that were narrowly written in such a way that they could capture all of the country. And for me, that was a better place to be. So again, I'm for my unanimity. I'm actually for not having a 7-6 court, but let's just have a 6-6 court. Why don't you just add 3 seats and make it equal so that the institution as a whole needs to take up less space in our lives. And to the extent that we just add 4 seats and it's still a partisan battle over how we stretch it, we won't really reach that point where we can rest easy that the elected representatives of the country are the ones who decide what our future looks like.
Thank you, Rakim. I also was skeptical of court expansion, believe it or not, a few years ago when I first started doing research for Take Back the Court. And I have to say, I really appreciate your perspective and reminding me how I did feel when I first started going through and into the court expansion mindset. I'll just say one other reason for a 7-6 court is because we have to undo a lot of what has been done over the past few years. It's not just a matter of now introducing a fair system. We also need to, this is not, we're going into a system on fair and equal terms. We have to undo what has been happening over the past decade or so, especially when it comes to democracy, when it comes to labor rights, when it comes to environmental protections. And unfortunately, I do think that does require a rebalancing that also reflects the composition of the country and also reflects that urgent need to go back and revisit some of these horrible topics, revisit these decisions, and frankly, overturn the negative precedent that has been set in the past few years, even just the past 3 years when it comes to things like Brnovik, when it comes to
You'll be there forever if you have to name them. You're totally
jobs,
right.
the whole batch of really terrible rights limiting cases that we've seen and the threats to democracy that we're facing. So I do think that a 7-6 court is what we do need to aim for. I think that the legislation that we currently have before Congress, the Judiciary Act of 2023, is good law. It's simple. It's like 4 or 5 lines. Anyone can read it. Anyone can look at it to see what was actually going to be enacted. And I think it's something that I'm hoping that everyone on this call pushes their congressional representatives to support.
Yeah. Unfortunately, they can't be placed on the ballot like politicians because they're appointed by the president, confirmed by the Senate as required by the Congress. So,
yes.
All right, we are running short on time. There is one last thing that I want to ask you all before we wrap up. And that is for both of you. And, hopefully we can keep this short because we are at 2 p.m. Can each of you give us a sneak peek into the next term? What are you keeping an eye on, and what should we as a public keep an eye on as well next term?
I'll cheat a little bit and give Chelsey a chance in case she's thinking about her very astute answer. We're keeping an eye on all of you. We've been seeing, our organization's been doing this work for over 40 years, and we've never seen more interest in the court from the progressive movement than we see today. And that is crucially important to any progress that we're going to make, whether it's court expansion, term limits, unanimity, any of the things that are being described. It will require you placing pressure on your elected representatives to take a stand on any number of these issues and to assign their names to bills, to offer legislation. The more we continue the churn of understanding that the court's role in our society right now is inappropriate, that it's exceeding its natural limits, and that needs to be reformed, the more likely we are to achieve reform. And so while we're looking at the court, we know that only bad things will come from the court. We necessarily have to attend to them because the downstream effects of the court's decisions have real world impacts on everyday people every day. And so that goes without saying, I think, but I'm really heartened that so many of you showed up to this call today to learn more, to remain engaged, and I hope that you'll spread the word that this is one of the central democratic issues of our time.
I'll give a more literal answer for now and then wrap up. But there are a few cases that I do want to highlight for next term. The first is a South Carolina gerrymandering case. So we're already seeing that door open to another racist map case happening just in October. We're going to hear arguments on it. We have the predatory payday lending industry challenging the very existence of the Consumer Financial Protection Bureau. We have this is, very much legal doctrine, but we have a case challenging how the administrative state is run. It's specifically around something known as the Chevron deference. It's very, very important to every area of your life, and it is probably going to be the biggest case of the term so far. There is a case concerning whether domestic violence recipients of restraining orders, so people who commit domestic violence and have restraining orders against them, should be allowed to have firearms. There's cases related that are potentially going to come up related to mifepristone, which is medication abortion, and FDA approval of that drug in all 50 states. We potentially will see another affirmative action case regarding K through 12 education that could have implications that go into housing. And there's also going to be a disability rights case on the docket, and they're not done taking up cases. So this is really just a very early preview. I do want to echo Rakim's thoughts that I'm very, very encouraged to see so many people recognize the enormous role that the court plays in your life, because I think that, up until a few years ago, it wasn't normal to have conversations with your friends and neighbors about Supreme Court decisions. And I think it is becoming more normalized. You're seeing more about it in the news. And I'm really, really happy to see so much interest in this, because it is really, really important. This is a currently totally unchecked branch of government that is exerting incredible amounts of control over your life. And my deepest hope is for all of you to stay engaged and to work to meaningfully check and balance and rebalance the court, hopefully through expansion, I've convinced you, but if not, through whatever means that you feel is the most appropriate.
Chelsey, Rakim, thank you so much for joining us today. And that does it for today's briefing. Thank you all to the audience also for being here. Next week, you'll receive an email with a link to a recording of this call and a Google Doc full of resources on how you can join the fight for workers' rights, among so many other issues. If you got a starting now email and you clicked on a Zoom link, in other words, if your name was participant when you logged on instead of your actual name, you still need to register to attend the other trainings and to be sure that we have your email so we can send you the toolkit and all these other amazing resources. Make sure you sign up so that you can also get the great tools that we talked about today, and of course, a recording of this webinar. We'll also be sending out reminders for future briefings and other great resources and tools, so be sure to register. Again, Chelsey and Rakim, thank you so much for being here with us. And that does it. Have a good day, everyone.